For over a decade, the public has demanded a full accounting of Jeffrey Epstein's inner circle. The gravity of his crimes left an enduring question about who else was involved and who looked the other way. The answers lie in a network that spanned multiple continents and permeated the highest levels of global power. Epstein actively cultivated relationships across international business, academia, and politics. His orbit routinely pulled in tech billionaires and prominent scientists, including Microsoft co-founder Bill Gates, who met with him multiple times to discuss philanthropy. The connections extended to heads of state. Former President Bill Clinton took numerous flights on Epstein's private jet for foundation-related tours across Africa. International royalty was deeply entangled as well, most notably Britain's Prince Andrew, whose long-term association with Epstein eventually led to the loss of his royal titles and public duties. The staggering volume of these high-profile associations made it impossible to ignore the systemic nature of his operation. The public demanded total, unfiltered transparency into every meeting, flight log, and correspondence. Epstein orchestrated horrific abuse, but his distinct leverage over the world's most powerful institutions created an environment where accountability seemed permanently out of reach. In November 2025, Congress passed the Epstein Files Transparency Act. The law carried a clear, strict mandate. The government had to release all unclassified records related to the investigation. 2 months later, the Department of Justice dumped over 3 million pages into the public domain, releasing hundreds of thousands of images, videos, and witness accounts. But despite that massive volume, the release was incomplete. Subsequent reporting confirmed that tens of thousands of records remained suspiciously withheld from the public eye. This deliberate omission sparked an immediate and intense backlash. The central allegation now driving congressional inquiries is that the government is not actively exposing Epstein's network. They are carefully curating it. By releasing millions of pages of less sensitive material, the government has provided a veneer of compliance while maintaining a firm hold on tens of thousands of specific, highly sensitive documents. The Department of Justice maintains that they have completely fulfilled their legal obligations under the Transparency Act. They announced that their January release would be the final one. To handle the workload, the DOJ cited a massive operation, formally stating that more than 500 attorneys and reviewers contributed to vetting the materials. The watchdog group American Oversight has filed an emergency lawsuit against the DOJ and the FBI. They are demanding the missing documents, along with the exact internal instructions and training given to those 500 reviewers. The lawsuit stems from explosive congressional inquiries, alleging that FBI staff were explicitly instructed to flag and protect any mentions of Donald Trump in the investigative holdings. The Justice Department aggressively tried to strike these factual allegations from the court record. A federal judge formally rejected that effort, keeping the claims front and center. The focus has shifted from the volume of the review to its intent, with 500 attorneys potentially serving as a filter to ensure specific political interests are shielded from public disclosure. The fallout on Capitol Hill was immediate. Lawmakers across the political spectrum reacted to the slow-walking, improper redactions, and the deliberate removal of documents from public view. This culminated in a bipartisan House Oversight Committee vote to issue an extraordinary subpoena to Attorney General Pam Bondi, demanding her appearance for closed-door testimony regarding the handling of the files. Congress is now attempting to override the Department of Justice's redaction process, forcing a struggle over whether the executive branch can legally withhold records mandated for release by the legislative branch. Attorney General Bondi will sit for that deposition within 30 days, setting a hard deadline to obtain the records needed to verify her testimony. This strict timeline is exactly why American Oversight filed their motion for a preliminary injunction. Lawmakers need the DOJ's internal review protocols in their hands before the Attorney General takes the oath to testify. Relying on verbal testimony alone is insufficient. Congress requires the documentary evidence to verify whether the Attorney General's claims of a fair, legally compliant review match the actual directives her department followed. Without securing those internal instructions, lawmakers will be flying blind into one of the most consequential depositions of the decade, unable to effectively challenge misleading statements with hard facts. If the review process was politically compromised to protect specific interests, the Transparency Act is effectively voided. The law means nothing if the agency executing it can pick and choose who deserves cover. We are left contrasting the sprawling historical vastness of Epstein's network with the narrow, opaque pipeline of the modern Justice Department. It forces a difficult question about the historical weight of this moment. We have to ask if the justice system is actually exposing the elite or simply modernizing the way it provides them cover. The ultimate test of the Epstein Files Transparency Act is whether the public ever sees the records that remain hidden behind the department's closed-door review.